Now in Chapter 4, we're going to continue looking at foundational cases, starting with Atkins and leading up to BAZE. So in Atkins v. Virginia in 2002, the court focuses on individuals with intellectual disabilities. Now you'll find when you're reading this decision that they're using the word mental retardation, and in 2013, the DSM-5 replaced that term with intellectual disability. Now, intellectual disabilities often mitigate criminal culpability. Atkins' IQ was 59, and the average IQ was 100. Scores within the 70 to 75 range are indicative of an IID, an individual with an intellectual disability. And Atkins' IQ put him in the bottom 1% of the population. Based on interviews with people who had known him his entire life, his school records, and the result of his IQ test, they ruled that executing those with intellectual disabilities is excessive, cruel, and unusual, and unconstitutional. Again, here we're using the evolving standards of decency standard, and they decided there was a national consensus against executing IIDs. 18 states had legislation banning it. Now, in Penry v. Linaw in 1989, this practice was upheld, but since that decision, 16 states have banned it, and 6 did so in the 2 years prior to the Atkins decision. So the consistency of this direction, the direction of the change, was important. The court also noted that various professional and social religious organizations opposed the death penalty for those with IDs. Now, they addressed the goals of deterrence and retribution, which we know are the 2 goals of the death penalty. Now, in retribution, the severity of the punishment rests on how culpable an offender is, but this lacks effective application on someone who is not completely blameworthy. In terms of deterrence, those with IDs cannot adequately process information, control their impulses, and logically consider the consequences of their actions, so they cannot alter their conduct based on the threat of punishment. Now, in the dissenting opinion, they said that there wasn't a conclusion that a national consensus had emerged. 18 states is not a majority. 19 states had not banned the practice. But again, they're not including all the states that banned the practice across the board. Atkins' mental disabilities were an issue at trial, and the jury still sentenced him to death. And we should support the power of the jury to make that decision. They also really laid into the majority for relying on the opinions of professional, social, and religious organizations, and said it's even more absurd to look at international opinion. Now, it's important to note Atkins' case was reversed and remanded. Okay, that means it gets sent back down for a new trial. In the new trial, they concluded he was not an individual with an intellectual disability, and they sentenced him to death. And now in 2008, this death sentence was overturned, but it was due to prosecutorial misconduct. Now, things to keep in mind here. The court doesn't define what an intellectual disability is, and it doesn't provide guidelines for the states. So now it's up to the states to determine what those guidelines are or how that's going to be carried out. And we don't have any real clarification until Hall v. U.S. in 2014. Now, the logic in this case is really important because it's relied upon heavily when deciding Roper v. Simmons. In Ford v. Wainwright, the court held we cannot execute someone who was insane at the time of execution. We already talked about Penry v. Linaw, and in Tennard v. Drett, the court held that it's unconstitutional to execute a person with mental retardation, even if the crime is not directly attributed to it. In Panetti v. Quarterman, they said a defendant's awareness of a state's reasoning for executing him is not the same as understanding that reasoning, and the defendant must clearly understand the legal reasons for an execution, otherwise the execution isn't serving its purpose. And in Hall v. Florida, Florida developed a rule that prevented anyone with an IQ over 70 from presenting evidence of an intellectual disability. And the court said that this is too rigid and this violates the 8th and 14th Amendments. Now, in 2002, in Ring v. Arizona, this case looks at the 6th Amendment right to a jury trial. Can judges be the ones who determine findings of fact or aggravating circumstances separate from a jury that serves to increase an offender's punishment? Arizona had a law that allowed a defendant to receive the death penalty in cases like Rings only if the judge finds the presence of a statutory aggravating factor not outweighed by mitigating circumstances in a separate sentencing hearing. So if the judge can find a compelling reason to sentence a defendant to death, then he or she may do so as long as there are no mitigating factors strong enough to necessitate leniency. And the court basically held that juries are the only ones that can sentence someone to death. Now the case is reversed and remanded back for resentencing. So basically it goes back and a jury determines the death sentence. So in the concurring opinions, the court held that all facts used to subject someone to punishment has to be found by a jury, and taking that right away from the jury fundamentally alters the process. Justice Breyer agreed, but thought this was an Eighth Amendment issue. And Breyer also cited retribution as a justification for the death penalty and said juries are in the best position to ensure this. In terms of dissenting opinions, they said judicial discretion should be given more respect. Courts should not treat facts or aggravating circumstances that increase sentencing penalties as elements of a crime, if it's not required by the Constitution or history or prior cases. And the court did not clarify if that decision was retroactive. So would it apply to cases that had already been heard? And later they clarified it is not retroactive. So it only applied to cases going forward. In Walton v. Arizona, it was held that trial judges have complete sentencing authority in capital cases. And in Apprendi v. New Jersey, it was held that only juries can determine facts that increase the severity of a defendant's sentence. Remember, we always want to be looking at what the most recent court rulings are because those are the ones that we're expected to follow. Now, in 2005, we have Roper v. Simmons. And this says, can we execute people who are under 18 at the time of their offense? Roper had several aggravating factors. His crime was committed for monetary gain. He killed in order to avoid arrest. And, quote, there was depravity of the mind and was outrageously and wantonly vile, horrible, and inhuman. They offered very little mitigation in his case. He had a lack of criminal history, and there was testimony that he was a good person. His age was only mentioned in closing arguments, basically the argument that juveniles are not as responsible as adults. Now, this was unsuccessful in appeals until Atkins in 2002. Simmons argued that the court's reasonings should apply to juveniles, and the Missouri Supreme Court agreed and commuted his sentence to life without parole. The state of Missouri then appealed to the Supreme Court, who agreed that the 8th and 14th Amendment do not permit the execution of juveniles. Again, we're looking here at evolving standards of decency. The majority of states reject the juvenile death penalty. There is consistency in a trend to abolish it, and the states that do maintain it rarely use it. The court set forth three main differences between adult and juvenile offenders. Juveniles are immature and irresponsible. Their conduct is not morally reprehensible as adults, and this is why states regulate their activities. Juveniles are vulnerable and have less control over their surroundings. They can't just pick themselves up and move themselves out of criminogenic environments. And they're often struggling to find their identity, which makes their traits more transitory. They also address retribution and deterrence and felt neither justification is served by executing offenders with diminished capacity. And Justice Stevens reminds us that we should evolve, that as we evolve, so should the Constitution in accordance with the intent of its original writers. In dissenting opinions, O'Connor did not believe a mere majority of the states banning the practice constituted a national consensus on the matter, and she felt that the decision should rest in the hand of jurors, that there may very well be 17-year-olds mature enough to deserve a punishment of death. Now, prior to this, we've talked about Thompson v. Oklahoma. Previously, that's unconstitutional to execute those who are 15 and under, and in Stanford v. Kentucky, prior to this ruling, had said it was permissible to use the death penalty for those who were 16 or 17 when they committed their crimes. Now, in Baze, we have Baze and Bowling versus Rees in 2008, and these are two cases addressing the constitutionality of lethal injection, which has been under intense scrutiny for years due to some botched execution. So they agreed to rule on the 3-drug protocol that was used by Kentucky. Now, the 3 drugs involved are sodium thiopental, which is an anesthetic meant to induce unconsciousness, pancuronium bromide, which causes paralysis, and potassium chloride, which induces cardiac arrest. Now, what can impact whether or not this is carried out as planned? Well, if it's administered improperly or the dosage is inadequate. But the court upheld the 3-drug protocol. And it's a rather complex and lengthy ruling that focuses primarily on errors that can result from lethal injection, which we'll cover in more detail in Chapter 6. But the court said that an execution is considered cruel and unusual if it prevents a substantial or objectively intolerable risk of serious harm. Now, the risk of pain exists with all executions, and the Constitution does not require us to eliminate that entirely. In the dissenting opinion, these members were concerned about the lack of procedural safeguards. They wanted to take additional steps to minimize the likelihood that the offender would experience pain. While awaiting this decision, states essentially stopped executions and began preparing backup methods should the 3-drug cocktail be ruled unconstitutional. Now, just some other cases of interest. Going back to 1879, the Supreme Court holds the firing squad is permissible. We know in 1890, electrocution is considered permissible. In 1947, the court said it is not unconstitutional to attempt to execute someone a second time if the first attempt fails. And in 2015, a much more recent case in Glossop v. Gross, they said the use of midazolam, the first drug, is not a violation of the 8th Amendment. And here we just kind of have a quick rundown of those foundational cases, the issue at hand, and how the court ruled. That wraps up this chapter.